by DGTS Delhi and Kolkata Zonal Units in association with FIO, CII, and Invest India. I am Vinesh Chaudhary, Additional Director DGTS, and I'll be the moderator for today's session. And before we proceed, I regret to inform that DGTS, Sri Manmohan Singh, sir is not well, so he would not be able to join the sessions today.
Yeah.
The scheme of advanced rulings in customs is a WTO recommended trade facilitation measure. It started in India in 1999, and the recently revamped Customs Authority for Advanced Rulings has started functioning from 4th January 2021 at Delhi and Mumbai. The scheme generally aims to reduce and minimize the time-consuming and expensive litigations and impart certainty in the matters of tax assessment. This session of webinar has been organized with the sole purpose of widely publicizing its provisions and its advantages so that more and more importers and exporters can take its benefit. The format of the webinar would be like, we'll have the introduction of the panelists first. Then there would be addresses by the inaugural speakers, followed by presentation, and at last we'll have the interactive session with the expert panel. I would also like to inform here to all the participants that the webinars organized by DGTS are for taxpayers' awareness and educational purpose only. The participants may refer to the legal text for understanding the details and legal implications. And during the webinar session, we would be posting feedback forms in the chat box, and I would request all the participants to fill it up with their feedbacks. Now, I would like to welcome Shri Surjit Bhujbal, Chief Commissioner of Customs, Delhi Zone. Sir has been kind enough to always, whenever DGTS has carried out any important webinar, sir has been very kind enough to join. I also welcome Shri Upendra Gupta, Principal ADG DGTS. I welcome Shri Manas Ranjan Mohanty, Commissioner and Customs Authority for Advanced Ruling, Mumbai.
Thank you, Vinesh.
Welcome, sir. Shri Vijay Singh Chauhan, Commissioner and Authority, CAR. It is generally called CAR in a short form. CAR Delhi. Miss Anamika Singh, Joint Commissioner and Secretary, CAR Delhi. And Shri Shantanu Agarwal, Deputy Commissioner, CAR Delhi. From the trade side, from the trade association side, we would be having Shri Ajay Sahay was supposed to join. He's from Dr. Ajay Sahay. He's DG and CEO, PO, but he's not been able to join because of some certain meeting in the Commerce Ministry. So Mr. Khalid Khan, Vice President FIO, is representing the FIO organization. Sri A.S. Bisla, Senior Advisor, Indirect Taxation CII, represents the CIA part. Now I request Shri Surjit Bhujbal, Chief Commissioner of Customs, Delhi Zone, to kindly deliver the inaugural address. Sir.
Thank you very much, Vinesh. Welcome all the participants for this Pan-India webinar on Customs Authority for Advanced Ruling. And we just overall, I think the participants will exceed 100 in the due course. It's a very healthy development, and I at the outset would like to thank the Director General of Taxpayer Services, both the Delhi and the zonal units, in association with the Federation of Indian Exporters Organization, Confederation of Indian Industries, and Invest India, who have taken all the pains and efforts for putting together this audience for this very important subject of advanced rulings. At the outset also, I'd like to thank Mr. Khan and Mr. Bisla for being here amidst us, and a special welcome to all the participants for today's webinar. We are aware that as per the Kyoto Convention and the WCO recommendation on binding pre-entry classifications, that information requests for advanced rulings need to be made in writing. Customs is required to issue the advanced rulings in writing, including providing the opportunity for an appeal also. Now, we all are aware that people who have already participated in this due process, time of making applications, we need to provide all the information, your brochures, etc., etc., and all the details of this. Our colleagues will take you through after this very brief inaugural. I think globally, what is expected from the customs administration is they should establish some specialized units to handle these matters, and preferably at central and regional levels also, so that a uniformity and consistent approach is adopted while attending to the issues on advanced ruling. Advanced ruling, as has just been mentioned by our compounder, that it provides certainty in business on in respect to customs duty liabilities, both in imports and exports. It is also interesting to know that as per some recent studies which has been carried out, it has some significant impact on the trade costs. And as per the OECD, sometimes it goes right up to 10%. And the contribution of advanced rulings have been estimated somewhere around 5.4% of that. So what is important for the success of any advanced ruling institution in any country to have a very clear legal framework for the regulation of advanced rulings, and to establish a specialized team, as I just mentioned a few minutes back, to have a very good and continuously improved ICT infrastructure, a very national computer database which continuously populates and gets updated. For rulings, will enhance coherence, consistency, and will bring in uniformity in approach. The monitoring mechanism on part of these established units is very important, because the whole purpose is to ensure that the request once placed needs to be attended on priority and as soon as possible. So that's the very purpose and the cornerstone of the advanced ruling. We at the same time we need to have a very continuous and robust public awareness campaign, and this is where DGTPS has been outstanding in its initiatives over the past many years now. Today's event, which will have our colleagues Anamika Singh and Shantanu taking you through regarding the technical aspects of this advanced ruling in customs. And end of the day, you'll have a very senior officers of the department, both Mr. Manas Mohanty and Vijay Singh Chauhan, who are currently attending to the advanced ruling appeals or requests at Delhi and Bombay. I think they'll be in the best position to answer your queries and to offer their valued advice. Over a period of time, of course, we know that advanced ruling institutions in India took off in very late 90s in a certain form. So this form changed in due course somewhere around 2018, and the continuous process, but it will, I think, very soon mature into a platform where it will be greatly beneficial for the trade and commerce community. I take this opportunity to thank DGTPS for having given me this opportunity to speak to you and interact with you very briefly. And I wish this webinar a grand success. Thank you very much.
Thank you, sir. Thank you for putting this entire topic on a perspective, broadly on international level as well. Now, I would request Mr. Khalid Khan, Vice President FIO, to share his thoughts on the topic.
Thank you, sir. A very good afternoon to everybody. Shri Surjit Bhujbal, Chief Commissioner of Customs, DZ, Shri Vijay Singh Chauhan, Commissioner at Authority CAR Delhi, Shri Manas Ranjan Mohanty, Commissioner at Authority CAR Mumbai, senior officers from CBIC and DGTS, Shri A.S. Bisla, CII, ladies and gentlemen. A very warm welcome to the Director General DGTS, Chief Commissioner of Customs Delhi Zone, and other senior officers from CBIC, DGTS for sparing their valuable time for this webinar on Customs Advanced Ruling, which is called as CAR. I would also like to welcome the participants to this session. Friends, the government's efforts to make business and commerce easy has been widely acknowledged. The CBIC has been taking various steps for ensuring ease of doing business. Various trade facilitation measures have been taken by Indian Customs in recent times, and CBIC has been constantly working for improvement and innovation in the system and their fallacy, which has resulted in some of the novel schemes by the system. Some of the major initiatives taken, such as 24/7 clearing at all the seaports and airports, single window for all EXIM-related issues, electronic out-of-charge facility, faceless assessment, revised authorized economic program AEO, facility of deferred payment, introduction of Tura and customs, complete online modules for IGCR, etc., has really facilitated the trade a lot. I would like to thank the DGTS CBIC for joining hands for organizing the webinar on Customs Authority for Advanced Rulings, which will help in busting the many myths and give clarity to the exporters. The facility for advanced rulings in the customs matter is important to facilitate the trade. This is an initiative of the government and commitment under WTO's trade facility agreement to minimize disputes for imparting certainty in the relevant taxation matters to attract the foreign direct investments and to pronounce ruling expeditiously, transparently, and inexpensively. The Customs Authority of Advanced Rulings CAR provides decision on classification of goods under the Customs Tariff Act 1975, applicability of an exemption notification, tax or duties, and under Customs Tax Tariff Act. Friends, in order to have the better understanding of the subject, we have best of the officers from CBIC, who I'm sure will leave no stone unturned to make this session successful. I urge all the participants to get your doubts clarified and take benefit of this proceedings. In fact, we get calls after the event that this is what is the clarification on this, what is the clarification. This is an opportunity for the members, for the participants to get all your doubts cleared today. Friends, these webinars are very important as they not only help the trade and industry in understanding the concepts, salient features of various schemes and processes, but the issues flagged by the industry get quickly addressed, as well as provides feedback to the government authorities, which further help in improvement and simplification of systems and processes. With the limited usage of the advanced ruling scheme, many industries have suggested as to why advanced ruling given in respect of classification of goods at a port is not automatically extended to all industry to save time of the industry as well as the advanced ruling authority. I understand that being quasi-judicial function, the same is not permitted, but the issue may be looked into from a broader approach. With these words, I once again welcome you, and I am sure the participants will be benefited from the deliberations. Thank you very much.
Thank you, Mr. Khan. I'm sure whatever points you have raised, we've got very expert officers in Sri Manas Mohanty Saab and Vijay Singh Chauhan Saab, and there are no better persons than them to answer these questions. And we also have Anamika here, so they would definitely be taking your issues. Now I would request Mr. Bisla from CII to give the trade perspective.
Sir, Honorable Shri Surjit Bhujbal ji, Chief Commissioner Customs Telejon, Shri Upendra Gupta ji, Principal ADG DGTS, Shri Vijay Singh Chauhan, Commissioner and Authority, Customs Authority for Advanced Ruling, Delhi, Shri Manas Ranjan Mohanty, Commissioner and Authority, Customs Authority for Advanced Ruling, Mumbai, Shri Vinish Chaudhary, Additional Director, Taxpayer Services, Ms. Anamika Singh, Joint Commissioner and Secretary, Customs Authority for Advanced Ruling, Delhi, Shri Shantanu Agarwal ji, Deputy Commissioner, Customs Authority for Advanced Ruling, Delhi, and my friend Mr. Khalid Khan, Director from FIO. Officers and industry participants, a warm welcome to all. Interactive sessions with CBIC officials give an opportunity to the stakeholders to get the deeper knowledge on the topics and understand the nuances of the provisions. The interactions also bring officers closer to the stakeholders, where officials also get new ideas and suggestions, which paves way for further improvements, remove bottlenecks, and to add EODB. So therefore, it is a win-win for both. DGTS CBIC, through its interactive webinars, is doing a tremendous and most sought after services of hand-holding stakeholders by making them aware of the changes introduced from time to time in customs and GST, explaining and sharing the government's view on various provisions. Industry and stakeholders get immensely benefited through these interactions, get the queries resolved, and also get deeper understanding of the provisions without routing through the consultants and litigations, thereby saving time and money both. In the series of such interactions, today's webinar is on a very important topic, advanced ruling under customs, though maybe less traveled, but an alternative dispute resolution method which give respite even before arising of the disputes. It is not so that business orders are given overnight, but after thorough brainstorming, including its costings, wherein customs duty is also an important element in factoring the import cost. All major expected issues have been covered under the ambit of advanced rulings, and that too available within a time limit. The process is also simple. So I would like to mention that it is based on best global practices to the extent that it provides clarity, certainty, and stability on the applicability of the custom duty and ensures the importer in advance to be free from any later hassles in the cross-border trades, putting a full stop on the very high risk of litigation time, interest, and penalty liabilities, which every business desires. Therefore, it is good mechanism for addition to the EODB and reducing CODB, it is cost of doing business. Stakeholders would get more time to devote towards their businesses by avoiding unwarranted litigations. Also would like to mention that the impact of this facility is so huge that though the advance ruling has been made applicable to the applicant, valid for 3 years or so, or till there is a change in law or fact, yet it carries a guiding force for traveling beyond the specified applicant, jurisdictional customs authorities, and also the time period, as other stakeholders also keep in mind and follow the ruling given to an applicant on a particular issue if impacting them also. Today, therefore, today's session is very important for the stakeholders to get a deeper understanding on the provisions, clear their doubts, and an opportunity to ask questions on their apprehensions and issues straightway from the authority present. On behalf of CII, its members, senior CBIC officials deserve kudos, particularly the authorities of advanced ruling and DGTS team for their valuable initiative for the interaction and presentations. Hope that stakeholders shall get benefited with the deliberations by the expert officers. I welcome all and thank you very much.
Thank you, Viswaji. Now we'll start with the presentation, and I would request Ms. Anamika Singh, JC, Kar, and Shantanu Agarwal, Deputy Commissioner, to go ahead with the presentation.
Thank you, sir. Respected Chief Commissioner of Customs Delhi Zone, Principal ADG, Directorate General of Taxpayer Services, esteemed panelists and partner from trade, commissioners and authority, Kar, Mumbai and New Delhi, and dear friends. Good afternoon. I would like to start a presentation on Customs Authority for Advanced Rulings. Next slide. Yeah, so the presentation is divided into the following fields: introduction and concept of advanced rulings under indirect tax laws, legal provisions and procedural aspects of CAR, recent amendment, and conclusion. Next, please. Yeah. So as we all know that classification, rules of origin, valuation, and eligibility to claim a particular exemption notification are high-risk areas regarding assessment of a bill of entry. More so because these aspects have direct impact on applicable duty rate. Here comes the role of advanced rulings. The applicant can seek advanced rulings on these questions, which are specified under Section 28H of the Customs Act 1962. The authority is bound to pronounce its ruling within a stipulated time period of 90 days from the receipt of the application. And the ruling will be binding on the applicant as well as on the port of import. Yeah, so here we will see definition of advanced ruling. as defined under Article 3.9 of Trade Facilitation Agreement of WTO, and simultaneously incorporated into Customs Act of 1962. So advance ruling is a written decision. Essentially, advance ruling has to be a written decision, and its objective is to bring certainty under the tax law. So it reads as an advance ruling is a written decision provided by a member to an applicant prior to the importation of a goods covered by the application that sets forth the treatment that the members shall provide to the goods at the time of importation. So it is about providing certainty of tax implications on an imported goods. Section 28EB reads as advance ruling means a written decision on any of the questions referred to in Section 28H raised by the applicant in his application in respect of any goods prior to its importation or exportation. Yeah, so advance ruling in indirect tax laws. Santanu, previous slide, please. Yeah, you can come to the next slide. So quite often we have been asked these questions that why the ruling issued by Authority for Advanced Ruling doesn't have pan India implications, and why it is issued to a particular applicant. I think the answer of the question lies in definition of public ruling and private ruling. As we can see that public ruling is being issued by government, and it's a government interpretation of a particular provision of law that affects a large number of taxpayers. Law enables CBIC to issue order, instruction, etc. to subordinate officers. So the applicability of public ruling, which is issued by a mode of order, instruction, or circular, its applicability is pan-India, while private ruling is essentially a transaction-specific and a particular applicant-specific ruling. Private ruling has been defined as it is issued on an application by a taxpayer seeking a ruling on its tax treatment in relation to a specific transaction. And the objective of private rulings is to provide support and a greater level of certainty to the taxpayer. Advanced ruling provisions were already there in pre-GST era. It was incorporated in Central Excise Act, in Service Tax Act, as well as in Customs Act. In post-GST era, it is available in GST Act as well as Customs Act. Yeah, so these are the advantages that we can expect from seeking an advance ruling. So we are aware that high level of tax disputes and uncertainty in tax environment can have damaging effect on the economy. In this scenario, advance ruling is an assurance to obtain the ruling without undue delay. I just want to show that how committed we are into issuing a ruling in time-bound manner. Just to show that, I would like to mention that the shortest time taken by the authorities to issue a ruling, and it is 36 days in one application and 47 days in another application. Even though the Act has provided 90 days time to pronounce a ruling. So we may expect even better rate of disposal in future of the application in view of the recent amendments carried out in the in Car Regulation 2021, which has made it mandatory for the applicant to specify only one port of import in the Farm Car 1. It is important because earlier we have seen up to 11 commodities in a single application and up to 6 ports of import in a single application. Of course, high number of ports of imports and commodities in a single application has direct impact on time taken in pronouncement of a ruling. So let's see. So first point was assurance to obtain the ruling without undue delay, that I have already explained, and with certainty of tax implications. So let's see how the ruling brings certainty of tax implications. A ruling issued by the authority takes into account the written submission of the applicant and the concerned commissionerate. Regards a personal hearing, it critically examines the documents and then precisely and specifically answers the question that have been raised in the application by the applicant. For example, classification is decided at 8-digit level to bring the certainty of classification. I would like to mention here that all the rulings and orders passed by the authority, both the authorities of CAR Delhi and Mumbai, are available in public domain on the CBIC website under CAR link. A live demo of the same will be given by my colleague Mr. Shantanu at the end of the presentation. So it will be quite useful if someone wants to go and see a ruling that has been passed in the past. So yeah, coming to the third point, second point, base suited to sort out complex issues of taxation. Taxation. So that I have already mentioned, that question that has to be raised in the application are specified under Section 28H of the Customs Act 1962, and these questions are regarding valuation, classification, rule of origin, etc. I would like to mention here that since its inception in January 2021, both the CARs have issued ruling on the matter of classification regarding more than 160 different commodities. So in all these applications, aspects of exemption benefit has also been covered, and these commodities are diversified in nature. It starts from natural products like pumpkin seeds, betel nut, betel classification of betel nut, and it goes up to the drones and technically advanced convergence devices like Alexa. So a vast and diversified nature of classification is there. So trade can be benefited by visiting the CBIC website. Although the authorities has not been tested on the question of rule of origin and valuation, we had received only one application about rule of origin and one regarding valuation. In that case, regarding rule of origin, a ruling was issued, and applicant had withdrawn the application of valuation. So now going to third point, rulings are binding on the applicant and concerned commissionerate. As already has been mentioned, it has binding nature, and the applicant is applicant as well as concerned commissionerate is bound to follow the ruling issued by the CAR. Saving of litigation cost and period. So advance ruling passed by the authority can be challenged before High Court only. So it saves the time of litigation, and informed business decision. Of course, once informed about tax implications, the trade can take a well-informed decision regarding their business. Shantanu, next slide. Yeah, so these are the previous slide. So these are the statutory provisions, Chapter 5B of the Customs Act 1962, from Section 28E to Section 28M. The Customs Authority for Advanced Rulings Regulation 2021, it basically prescribes procedures that has to be adopted by the Secretariat, and it provides guidelines also to fill up the form CAR 1 and CAR 2 for the applicant. This regulation has recently been amended by the Notification 63/2022 dated 20th July. So these statutory provisions has further been divided into three parts: organizational structure that covers two authorities with their jurisdiction that is situated in New Delhi and Mumbai, and accessibility regarding eligibility and admissibility of the application, subject matter that can be covered in the application, legal certainty that is being provided, like ruling is binding in nature and time-bound ruling, validity or sunset clause of 3 years, and appeal provisions. All these aspects in detail will be covered by my colleague, Mr. Shantanu. Over to him. Thank you.
Thank you, ma'am. So as ma'am has already specified, we will be going into the details of the organization structure, accessibility, and legal certainty that is involved in the that is involved in applications for custom authority for advanced rulings. So first we will go for the CAR's jurisdiction. So yeah, I'm sure that you will be this map of India must be visible to you. The color, the states which are colored with yellow color are the places where the jurisdiction of CAR New Delhi stands. That is the applicant having a registered address in these locations have to file application for advanced ruling to CAR New Delhi, and those in blue color have to file application for advanced ruling to CAR Mumbai. Apart from this, the law also allows that if any applicant has provided an address which is outside the territory of India, that authority shall be situated at Delhi. So till now, since last 1 year, we have actually more than 2 applicants that have been of foreign origin. So regarding eligibility and admissibility, if you can see this there are 3 criteria which are able to, which we can see to define what is who is an eligible applicant. So an eligible applicant is one who will be holding a valid IEC code. He must be exporting any goods to India, and the authority has been given a power or responsibility that with justifiable cause to the satisfaction of the authority, he can allow an application to be filed by an applicant. With respect to the rejection of the application, there are only 2 clauses which have been given in the law. Section 28I 2A says where the question raised in an application is already pending in the applicant's case before any officer of customs, the appellate tribunal, or any court. And section 28I 2B says where the question raised in the application is the same as in a matter already decided by the appellate tribunal or any court. So summarizing, if the application, the questions raised by the in the application should not be pending before an officer of customs or appellate tribunal or any court, and the same matter should not have been already decided by the appellate tribunal or any court. Besides this, if any application that we see that it is liable for rejection, the law allows an opportunity to be given to the applicant to present his case, and an order has to be passed by the authority where the reasons are listed down why the application was rejected. This is the scope of the CAR, that is application that is defined in section 28H. As ma'am have already detailed out that these are the questions on which the applications can be entertained by CAR, where first are those applications which involve the issue of classification. Then we have the issues of exemption notification. Third is the principle of valuation. We have specific duty notifications. We have questions to determine origin of goods. And also the central government can notify any other questions which can come in the ambit of section 28H. So these are the scope of the custom authority for advanced ruling. Trade facilitation agreement desires to create a conducive environment for trade to import into India, to import to a country. So for that, it is a necessity that these rulings should be given in a time-bound manner. As ma'am has already said, we are bound to issue ruling in 90 days. So Article 3.1 of the Trade Facilitation Agreement says each member shall issue an advance ruling in a reasonable time-bound manner to an applicant that has submitted a written request containing all necessary information. So the Trade Facilitation Agreement gave a base which was incorporated in Section 28I-6 of Customs Act, where it was mandated that the authority shall pronounce its advance ruling in writing within 3 months of the receipt of application. Now going on to the binding nature of the ruling. So whenever someone thinks about custom authority for advance ruling, it is very important that he wants to know what is the benefit of it. So the benefit is the binding nature. See, whenever an application comes to custom for decision towards to the custom authority for advance ruling, So the authority listens to both the applicant and the Principal Commissioner of Customs, and both views are weighed upon and respectively ruled upon. That is why the ruling that has been issued is binding on first the applicant who sought it, second on the Principal Commissioner of Customs or the Commissioner of Customs, and the customs authorities subordinate to him in respect of the application. But the application, the matters that have been referred to in the application that have been mentioned in subsection 2 of section 28H are those matters which are basically binding in nature. Any matter which has not been mentioned in the application is not binding on either the applicant or the Principal Commissioner of Customs. So there are three clauses. It is binding on the applicant, it is binding with respect to the matter referred in the application, and third, it is binding on the Principal Commissioner of Customs and Commissioner of Customs, which are mentioned in the application. With respect to the validity, so section 28J2, this has been recently amended, wherein it has been given that the advance ruling is valid for 3 years or till there is a change in law of facts, whichever is earlier. To avoid inserting section 28K says where the authority finds that an advance ruling pronounced by it has been obtained by an applicant by fraud or misrepresentation of facts. In such cases, customs can so in these cases also the ruling becomes invalid. So in eligibility also, last we have discussed in this eligibility, I've already discussed section 28I, 2A and I2B, which gives mandate for the rejection of application if the someone does not disclose these conditions and then takes a ruling on it. That section 28K allows the authority to say that the ruling is void if it is given by if there is a fraud or misrepresentation of facts. And also in such cases, custom can proceed to issue demand for the short levy of duty under section 28(1) and 28(4) of the Customs Act. So this is all about validity. So recently, see, Custom Authority, as Vinesh sir has already discussed, that the Custom Authority for Advanced Ruling has started working in 2021, February 2021. January 2021. So this law is evolving. So recently, these amendments have been brought in by the Finance Act 2022 after taking various recommendations from the trade and the departmental officers. And section 28I, earlier in section 28I, the physical filing of application was mandatory, but now we are paving for filing of e-filing of applications. The module for e-filing application is being developed by the department, and we are expecting it to be rolled out in the near future. Section 28H, with respect to the withdrawal, it was earlier said, the law earlier said that the applicant was given 30 days of time to withdraw his application, but now he can withdraw an application anytime before an advance ruling is pronounced. With respect to the validity, earlier it was valid till there is a change in law and facts, which still stands now, but the sunset clause of 3 years has been incorporated in the law. And this has been done on the to comply with the recommendations of the Trade Facilitation Agreement and the international best practices with respect to advance ruling. So this is the procedure of appeal. See, whenever a car issues a ruling, it is, as I've already discussed, it is binding on the Principal Commissioner of Customs or Commissioner of Customs and the applicant. So the appeal
will say it is other ruling. If we want it for 3 ports, then fee will be, you'll have to submit 3.
So the appeal on this ruling can be filed only by either of the two, and it can be within 60 days from the date of communication of such ruling in or order in Car 2 or Car 3 form. And as ma'am has already said that this the appeal procedure, the appellate authority for any ruling of Car is High Court. So appeals so filed is a custom appeal and not a writ petition. It is an important point to be noted. So this is the overall broad flowchart procedure of how the application proceeds. So if we see this yellow bubble, we can see that whenever it is a starting point, and when an application is received in Car, it can go on either in 2 directions. Either the applicant can ask for withdrawal of the application. If he does not do so, we do a work and try to find any defect or deficiency if there are any. If there is any defect of deficiency, we ask the applicant to correct the same, and it is considered as a fresh application. If we find that the application is free from any defect of deficiency, the application is forwarded to the concerned commissioner or principal commissioner of customs to give his comments on the matter. And these comments, when are received, are examined. So these procedural wise, the custom authority decides on two matters. First is the admissibility of an application, as we have already discussed earlier, and secondly on the merits of the case. So first, after receiving the comments, we see on the admissibility of the cases. If the application is found to be inadmissible as per the provisions of the law, the comments of the commissionerate are also shared with the applicant, and an opportunity for personal hearing is given. If during the personal hearing, if the authority feels that the law allows the application to be admitted, it is allowed, and the different procedure is followed. If it is found that the application is not admissible, the authority issues an order and the application is rejected. In the order, as I have already discussed, it is a speaking order, and the authority has to give the reasons behind which the application has been found inadmissible. If the application is found admissible, the comments comments of the principal commissioner of customs are sent to the applicant. A personal hearing is conducted, wherein the department is represented by the commissioner of customs, and the applicant is represented, and a ruling is issued. When the ruling is issued, as I've already discussed, both the people, the court and the applicant has an appeal procedure that they can take up, or if there is no appeal that has been filed, the ruling is binding. So this is a small basket of examples of commodities that that we in Custom Authority for Advanced Ruling in Delhi and Mumbai have ruled upon or have viewed upon. So first we can see we have given rulings on petrol cars, we have given ruling on electric cars, we have given rulings on composite electronic devices, which include Alexa devices. We have taken up matters on essential oils, on toy cars, on drones, on flow meters, various types of chemicals, various products and preparations and raw material involved with betel nut. Then we have spray equipments. Then we have recently issued ruling on gold scrap, various type of fibers we have taken into considerations, including plastic fibers. We have issued rulings on laminates, and we have also issued ruling on various electronic devices like desktop monitors, etc. This is just a small basket of, I'm trying to showcase that the variation of products that the authority has dealt with. So these are some do's and don'ts, or we can say that we encourage and we discourage. We encourage that the complete description of the product that has been highlighted in the application should be given. Secondly, we encourage that all relevant facts accompanied by the evidences should be filed and then should be given with the application, and giving an opinion on the issue along with supporting arguments justifying your stand. And we discourage applying for advance ruling if the matter is already pending, because the ruling in that case can be given null and void, and the application can also be rejected. Secondly, applying for advance ruling if the matter is already decided by any court or tribunal, because of the same reasons, including multiple products in a single application, including multiple ports of import in a single application, misrepresentation or hiding of facts. So these are encouraged, and we encourage and we discourage these points, so that it is conducive for the authority to give fast and crisp rulings on the application that have been filed to us. So now I'll take you to where if all the participants can spare some time to wait a second. Yeah, if I would request all the participants to spare some time to see what we have worked since last 1 year. If you go to cbic.gov.in, this kind of website opens up. you can see this car link in the front page. If you click on this, you get our entire page. Here we have detailed out all the rules, all the procedures. These are the car regulations and car forms that are mandated by the law, and these are all the details of the rulings. Every order is has been uploaded here. It is open source. It is open to everyone. Anyone can. I would request everyone to go through these. These are the subjects on this. We can see the subjects on which we have ruled: handheld computer devices, animal feed supplements, vitamin prefixes, and see the number of rulings that we have given. These are all given by Mumbai, and these are Delhi. So you can see that we have given numerous rulings on the preparations and raw materials of betel nut, as we have discussed earlier. Yeah, that's all from my side. Thank you.
Thank you, Anamika, and thank you, Shantanu. It was a wonderful presentation. Now we'll go to the next stage, which is interactive session with the expert panel. Sir, would you like to have some opening remark before we get into the questions, or we should straight away get into the questions?
I think we can go to questions straight away because this subject has very much been explained by Anamika.
Right.
And Shantanu, and even before that, the Chief Commissioner also has spoken. So it's better that we can, whatever concerns, I understood the concern of Mr. Khan, that ruling should be applicable pan-India. There is an alternate view on this. That alternate view is that when you make an application, you name a commissioner, you name a port. So comments of that commissioner is called, and he has a chance to participate in the proceedings. But the other commissioners in the other ports, they don't have. That's the view on that. Having said that, both Mr. Chauhan and I believe that once the ruling is passed, in respect of that importer, it should be applicable all over the country, wherever it might be. That is how the US cross ruling and most other progressive customs jurisdictions work. Like Shantanu and Anamika has pointed out, the law is pretty nascent. We are infants practically. So maybe in next year's budget, or yes, this should come. Discussions with the board is on. And any other questions, please feel free to go ahead.
So the questions can be asked in the chat box, and also you can raise your hand and ask questions. We have some questions already in the chat box. There is one question from Ms. Anubha, and this is regarding that mention of only one jurisdictional principal commissioner in the
jurisdiction is okay. Vijay, go ahead.
Yeah, Vinish, so just before the amendment to the regulation, it was you could add any number of mention any number of ports. But before I go to that, let me just take just 30 seconds to say that very rarely do we ever have a webinar where the moderator is perhaps most well versed with the subject being discussed. Vinish was the secretary of the Authority for Advanced Rulings when I joined, when the authority was created. And if we have been able to dispose of a whole lot of legacy issues well in time, a whole lot of credit goes to Vinish for sorting them out, because when the authority was created in Mumbai, it was Manas as one-man officer and me in Delhi as one-man officer. Vinish actually supported us to hit the ground running, and we are proud to have carried the baton so efficiently handed over to us by Vinish. Thank you very much, Vinish. Public acknowledgement of your contribution to advanced ruling in the country. So getting back to the question. So at that point of time, we were having a challenge. I have issued a ruling which covers about 11 ports, and so has Manas number of, and we did face a challenge. So there was a question of, reducing the number. And I remember that in the last webinar, which was held, I was asked this question and I said, please mention as many. There are 250 ports mentioned for import in the country. I said, mention as many as you wish to. And I promised to give you a ruling relating to all of them. But 1 year later, I would go through and check how many ports have you actually used. And if the number is less than 10% of the ports used, then please take me out for dinner. In the amendment, we have gone down to 1, which is perhaps moving the pendulum to the other extreme. We do believe that there should be a possibility to have somewhere in via media. Till the time the change doesn't happen, all that you have to do is to submit more than one copy of the same application, change the number of the port. Believe me, it is more difficult for us with limited resources available to handle exactly the same application for 3 ports than it would be for you to make photostat copy of the 3 applications, change the names of the port, and add a demand draft for 10,000 rupees. So we are as concerned about it as you are, that the numbers should not be 1, but as the rules say. And in fact, section 28M binds the 2 authorities to follow what the regulation says, which is made by CBIC. So we do recognize that the number should be minimal, but number as 1 may not really be the best possible solution. From there, I actually take it that, you see, Manas said that, and my chief commissioner mentioned that earlier, that advanced ruling is in the evolutionary process. We are at our early stage of formation, and we are dealing with a whole lot of issues, and those issues actually tell us where the shoe pinches. So unless we have more number of applications and more participation from the trade, we would not be able to move forward and find a solution on the basis of evidence. Today, when we speak and we say we are able to deliver advanced ruling in time, we do it on the basis of the evidence that we have. So everything I say, it would be on the basis of the evidence that we have gathered of our working in about 1.5 years by now. Having said that, we'll move forward and see how best it eventually settles down in terms of the number of ports that will be covered. Thank you.
Thank you, sir.
And just to add to that, Vinesh, like I said, if sometime in future the advance ruling is made applicable pan-India, then the question of one commissioner or more than one commissioner will automatically disappear. Then Mr. Khalid Khan also raised the issue of why the ruling should not be availed by other reporters. So this has been explained by Anamika, and I can briefly touch upon. There is a need to distinguish between private rulings and public rulings. The advanced ruling authorities are basically giving you private rulings, so that would be applicable only for the person who has applied for it and got it. Having said that, advanced rulings, the advanced ruling for other importers can certainly have persuasive value, because if you have an advanced ruling for Navaseva and you are producing it in Calcutta, the Calcutta officer would not be able to reject it right away. He has to give some consideration. So it is not that it is totally useless, but it's simply that it's not binding. Then there is Anubhaji, who knows about jurisdiction. See, jurisdiction is not according to the port of import. Jurisdiction is based on the address of the applicant. So basically it says that if you are an importer applicant in Leh, but wants to import from Tuticorin, so you come to the authority at Bombay and not Delhi. So, and vice versa. So the address of the applicant will determine the jurisdiction. Next, any question? Let me have a look.
So there's one question from Mr. George Paul. And he basically says that the companies have to many times submit codes for supply of goods to a customer in India, a finished product or the parts of a product for manufacturing. Is there any facility to get clarification on BCD rate at the time of having to submit a code to the customer? The transaction will happen after the company gets a purchase order from its
Oh
customer.
yes, absolutely. Why not? See, anybody now, as the law stands, anybody with a valid reason for making an application can do so. And we are, Chauhan and I, we are of course on our way out, but we have been very liberal in granting any such request. And in fact, I keep joking, even a commissioner of customs also under the act can come and ask for an advance ruling.
Okay, sir. There is one question from Mr. Bijender Kumar. Being authorized customs broker, can advance ruling application be submitted by custom broker on behalf of importer exporter?
Yes.
Absolutely, yes. The fee is 10,000 rupees. Lokesh ji.
Yes.
And then Mr. KK Singh. Yes, the definition of advance ruling, if you read, it says that before the act of importation and or exportation. So the first impression is that if it has already been imported, then no advance ruling application can be filed. But you go down to 28I and read it along with the definition, you have a different impression. So currently, the interpretation that we are relying on is yes, even if there has been prior imports, you can still apply for an advance ruling, provided that the prior import is not stuck up in litigation, either before the officer of customs, tribunal or court, or the court or tribunal has already not ruled on that. Having said that, the advance ruling will only have prospective effect. It would have no effect on the imports exports which had already taken place.
So can we take some hand-raised questions? Those people who have already raised hand.
Yes, yes.
You can start
Please go
with
ahead.
some.
Please go ahead.
Yes. Please go ahead. Please go ahead.
Miss Niharika Shidaye. So I'm unmuting you. Mr. Anant Kumar. Mr. Anant Kumar, you can ask your questions. Mr. Anant Kumar, you can ask your questions. Unmute yourself and ask your question.
Yes, thank you, sir.
Yes.
Sir, we are having a advance ruling issued in September 2015. It is relation to one product, whether it is our manufacturing is called manufacturing or service. So in this product, so now 2015. So as we heard the discussion, like after 3 years, I think expire or something I heard. And another is now service tax is also not there. It's converted into GST. So shall we go for renew it or new application to file, sir?
Is your advance ruling on customs or service tax? Because you are talking of manufacturing and service. So customs
yes,
is not on manufacturing and service. Customs is on import of goods into India.
Yes, sir. It's issued by this CECS. It's the New Delhi, sir. It's excise customers.
The authority was same for all three: central excise, service tax.
Okay.
In fact, 4: customs and income tax. The authority was same. But
Yes, sir.
the subject matter that you are indicating appears that it was a question of whether it is a central excise duty would be applicable or a service tax would be applicable.
Yeah, it's a service tax, sir.
That being the case, this is outside the purview of customs advance ruling.
Right,
This
sir.
is now a subject matter of GST advance ruling.
Okay,
But
sir.
now in GST, both the goods and services are intertwined in such a manner. I don't think the issue is relevant any longer. You can discuss it with somebody who knows this subject.
Sure,
but
sir.
this issue may not be relevant any longer.
Okay, sure,
In
sir.
any case,
Thank you.
this is not in the purview of customs. Vinesh,
Yes, sir.
I see a couple of more questions in the chat box. Mr. Guru Sukla,
Yes,
who says
Yes,
that
sir.
if there is an advance ruling for another importer, can somebody else apply for that ruling? Why not, Mr. Guru Sukla? Absolutely so. It is to make our life easier. No, if we have already given a ruling, so we can give you a ruling quickly. You can. Anamika was saying that the earliest, fastest ruling is 36 days. Maybe in such a case, we will be able to give a ruling in 10-15 days also.
And let me just add to that to say that if there is a ruling on classification of a particular product, if you want to have the benefit of its binding nature, you'll have to take an advance ruling for yourself. Otherwise, that continues to have only persuasive value, as Manas had already pointed out.
And then Mr. Vinay Nodial, if you have an advance ruling and the commissionerate has not filed an appeal before the High Court, then no, the assessing officer cannot raise a dispute on the classification at the time of assessment. And then Mr. Arun AL, raw material from Japan, and they are availing duty exemptions from FTA, HSN code followed by Indo-Japan FTA is so Indian customs follows. So, see, basically what will happen is when you are importing goods into India, we will follow the Indian customs tariff. Broadly, because we are all bound by WCO, we are all WCO countries, Japan and India have fairly similar tariffs. We may be different on subheading level at some places. But having said that, for the legal purposes, it is the Indian customs tariff which will be valid and not what Japan customs follows.
Sorry.
Niharika ji, she asked, do we need to apply advance ruling application for ports in which we are transacting? Yes. And now that Mr. Chauhan has explained, it's not something that we look forward to, but you'll have to apply different applications for each port. Sir, can an ICD be an applicant pertains to any import policy against CTH? This is something that I don't understand. Mr. Lokesh Jain, can you explain your question, please?
I'm asking him to unmute him.
Yeah,
Lokesh Jain,
Lokesh Jain.
Yes,
so
please
thank you very much, sir, to allow me to put my question on this platform. So, sir, my question is that we basically are a broker company, who handling multiple solutions, but so we want to import some commodity which is a restricted commodity at limited ports. So in this case, can ICD also be an applicant, because they don't have, sometimes it happens that ICD itself doesn't have the clarity, whether to seek from the department whether this can be bring at their port or not. So in this case, can ICD be an applicant against any CTH, looking for clarity under any CTH? For example, import of new vehicle which is limited at specific port. So can ICD be an applicant to seek the clarity?
See, I already said we have to take a very liberal attitude as to who can apply. Okay, so having said that, then the question that is asked has to be within the parameter prescribed in 28H. Policy restrictions, unfortunately, is not a part of that. So, if any question relates to policy restrictions which DGFT imposes, you will not get an advance ruling on that. If it is relating to a customs notification, yes, you will get an answer to that.
Okay, thank you, sir. Thank you.
Mr. Arun AL, is he still wanting to ask question? He has still raised his hand.
Yeah, please. I answered his question, but you can ask again.
Mr. Arun, if you still want to ask any further clarification, you are unmuted, you can speak. No, sir.
Then in the meantime, one question from Mr. KK Singh, can car rule on IGST collected under Customs Tariff Act? Yes, Mr. Singh, car can and we do rule on IGST to be levied at the time of import. Then Mr. Alok, their import will come in 6 months. Can they apply early? Yes, you can apply early. So, Mr. Arun L, that question I can again expand a bit. I recently went through an application where the Malaysian customs was classifying the commodity under a different subheading, whereas in Indian tariff we classify it under a different heading. So the importer, actually their supplier in Malaysia, they approached Malaysian customs. So the Malaysian customs said ruling from Indian customs, so that we will amend the entry, tariff entry in the exporting, yeah, or you get it from a chamber of commerce. So I think his issue is relating to that. Yes. Japan in their export documents may be giving a different tariff heading, whereas in Indian entry documents, bill of entry, the tariff entry. I am sure if you come forward with your exact case in an advance ruling application, either before Delhi or Bombay, depending on your location, you will get a clarity on this.
So there is another question, sir. The last one.
Vinish, allow
Yes,
me
sir.
to come in. Manas has just now mentioned about the ruling on IGST on imports. So he's right that the Custom Advance Ruling Authority can answer that question. But when the same commodity after import is sold within India, so then that ruling would not be applicable on the domestic supplies. So that point must be noted by the person who has, asked this question. Because he can't claim that while importing, the Custom Advance Ruling Authority has said that the IGS, for the IGST purposes, IGST on import purposes, the rate is this much or the classification is this much. For GST purposes, there is a separate advance ruling authority and they would be the jurisdictional authority for deciding that. Their ruling would have persuasive value, but it will not be binding on the GST officers. That point I thought I must clarify.
Absolutely, sir. You are right. As I have been stressing, we are purely customs, only entry point decisions. Whatever transactions take place thereafter, these decisions should not apply. Then there is a question from Mr. Dayanand Kotian. They have got an advance ruling for a certain port. Due to business reasons, they have to relocate to some other ports from Mumbai to Chennai to Mundra. So whether the answer is no, the ruling that you have got for Bombay are not binding on Chennai and Mundra. It would have persuasive value, but not binding. So if you want binding rulings, please approach again.
My counterpart here.
No more questions in the chat box.
Yes, sir. No more questions in the chat box and no more raised hand. Actually, there is one. No more raised hands, sir. No more raised questions, sir. I think it has been so clear.
Vinis, just a minute. I had a great time, and I speak for my colleague, Mr. Chauhan also. We enjoyed our stint as advanced ruling authorities hugely. We saw so many different interesting products. Some were really eye-opening, and we wish more and more members of the trade would come forward for more advanced ruling. And thank you, CII and FIO. They have partnered with us before for different webinars. Thank you to them and everyone who has attended this webinar today. Thanks to them. And any doubt you have post webinar also, you are free to contact the secretary in Bombay, Mrs. Vinita Sekhar, or in Delhi, Mrs. Anamika Singh. We would be happy to assist anybody who has a doubt, any question, in whatever manner we can help you. We would be doing that. Thank you very much.
Thank you, sir.
Vinish, before you put it for the vote of thanks, I would like to thank both Manas and Vijay because they agreed to participate in this webinar on my personal request. So thank you to both Vijay and Manas. Thank you.
Our pleasure, sir.
Thank you so much, sir. Thank you. Sir, and for a change, sir, this time the vote of confidence, vote of thanks is being done by me only, sir, because I had such esteemed experts here, so I thought I'll do it myself. And really thankful to everybody, to the participants. First of all, I was a bit nervous whether we'll have the numbers or not, but we had good number, around 180, 85 people were there to participate. Thank you so much to Chief Commissioner of Customs Delhi Zone, Shri Surjit Bhujbal Saab, Upendra Gupta Saab, Vijay Singh Chauhan Saab, Banas Mohanty Saab, Anamika Shantanu, and Mr. Khalid Khan, Mr. A.S. Bisla. Thank you everyone for this wonderful interaction we had. Thank you so much.
Thank you. Thank you. Thank you.
Thank you, sir.